Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble, and to petition the government for a redress of grievances.
Hi, I'm Ann Hogan. I'm Dean of the College of Communication and Fine Arts, and it's my pleasure to welcome you to today's event, Exercise the First. We're going to be hearing from an array of speakers about this powerhouse amendment, which includes 5 freedoms within it. The First Amendment is first for a reason. It is fundamental to who we are as a nation. I want to thank the faculty of the Department of Journalism and Strategic Media, notably Tori Cliff, and the students and the speakers who organized and took the time to participate in today's event. And I want to thank you for taking the time to join us. I feel very sure you're going to be glad that you did. Thank you.
My favorite freedom of the First Amendment is the freedom of religion, because Congress is unable to establish a state religion that I'm forced to follow or prohibit the practice of any religion that one so chooses. This means that I'm able to practice what I want to believe, even if that means nothing at all, and that others are able to do the same. This protection also means that as people are able to believe what they want without fear of retribution, they are then able to feel confident in exercising the other freedoms protected in the First Amendment.
Hello, my name is Dr. Ron Serino, and I'm the Director of Interdisciplinary Studies at the University of Memphis. Today, I would like to talk a little bit about the freedom of religion. The First Amendment to the U.S. Constitution says that the United States Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This amendment comes out of the context of European Christian governments that the United States prior colonies came from. And in those countries, governments had established religions in Christian Europe, whereas the state and the government were essentially the same. The churches were supported and controlled by the state and vice versa. The other context for this amendment comes out of the religious wars between Roman Catholics and Protestants in Europe in the 1500s and 1600s over who would control certain regions and the churches thereof. The peace treaties, after these very long, decades-long, sometimes more than 100 years long wars, resulted in some degree of religious freedom, at least in terms of private worship in the home. The churches in the towns and cities were still controlled by the state church or the state government, which controlled which type or brand of Christianity it was, whether Roman Catholic or various types of Protestants. Some of the North American colonies that were established by the English in the 1600s, some of these colonies were established by people fleeing religious persecution from their state church, primarily the authorized or established Church of England. But most of these colonies reestablished their own religion or brand of Christianity as a locally exclusive and publicly supported type of church, whether it was the Congregationalist or the Anglican Church, the Roman Catholic Church, the Quakers. One colony, Rhode Island, specifically was established as a safe haven for religious minorities by an early Baptist leader. Some people often say that the United States was established as a Christian nation and remains a Christian nation. But most of the founders of the United States were deists. And deists is certainly influenced by, comes out of Christianity, but it's a type of Christianity that favors reason, not revelation, divine revelation, or sacred text revelation in order to understand the world, using reason to understand the world. And the image that is often associated with deists is that of the watchmaker, God as someone who created the world, wound up the watch, but then is not involved in the day-to-day operations of the world, sort of a disengaged creator. The idea that the First Amendment to the Constitution puts forth is that there shall be no nationally established religion. That's because different states had their own established religion, so that originally it wasn't applied to the states. States could still have official or established religions, but in the 1940s, especially, a Supreme Court case made clear that this separation of church and state applied to the states as well. That is, states couldn't have their own specifically religiously favored or promoting kind of laws. But there's been an ongoing political tension about the influence of Christian values, Christian texts, and Christian traditions on US society and the legal system. Especially with the development of Christian fundamentalism in the early 20th century, the rise of the religious right started by people like Billy Graham, who were very involved in politics and encouraged people to be involved in politics, groups like the Moral Majority and the Christian Coalition that attempt to put conservative Christian values into US society and the legal system. There's been ongoing debates about teaching of evolution in schools, for example, or sex education, what to do about a prayer or Bible study in school, or access to abortion or LGBTQ rights, for example. There's also been ongoing tension and controversy over Native American indigenous rights, especially with regards to religion and the practice of their religious culture, which have been outlawed in various times and places in the United States, such that in 1978, there was an act passed, the American Indian Religious Freedom Act, to affirm the religious liberty of Native Americans, including access to sacred sites. Further, there was a 1993 legislation, the Religious Freedom Restoration Act, to affirm the legality of the use of peyote, for example, in Native American religious ceremonies and access to religious sites. There are ongoing legal battles about the commercial use of sites that are considered sacred to indigenous people in the United States. Will there be commercial development, resource extraction, pipeline placement, such as the recent Dakota pipeline controversy? Where do my rights end and yours begin? Controversies over the wearing of religious garb, for example. Can a Muslim woman wear her hijab in public? Can she wear it at work or while teaching in school, for example? What about financial assistance to religious organizations? Can there ever be any public money that's funneled to religious organizations for charity, for example? Where does that line drawn? What about tax exemptions for religious property? These and other issues are ways that the First Amendment has been applied and debated in the life of the United States. Should religious organizations have access to public property for religious purposes? Should there be religious exemptions from laws that apply generally to everyone? And what about laws specifically like closing businesses on Sunday or restricting sales of certain items on Sunday? Can people object conscientiously to serving in the US military on religious grounds? Can people religiously solicit you in public or on the street or in your home? And can there be religious displays on public property, such as, for example, the Ten Commandments or a cross? And so, again, where do my rights end and yours begin? The Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, which means the government should not promote any religion over any other and should allow any citizen to freely express their religious expression how they see fit, as long as it doesn't infringe on the rights of others. Thank you.
Hello, my name is Akasha Austin. I would say that my favorite freedom of the First Amendment would probably be freedom of speech. I say that because for centuries, many African Americans were unable to voice their opinions on a variety of topics here in this country that we love so much. As a Black woman, I take pride in the fact that thanks to those who came before me, my voice can now be heard.
Okay, so when was the first time that I recognized or understood how important freedom of speech was? I think I've kind of always felt that way because I came of age, matured, whatever you want to call it, in the 1960s. And of course, it was kind of hard for anybody not to believe in the 1960s that in the importance of freedom of speech, and to kind of assume that, everybody had it, that this was just something that you coming of age in the urban South, I'll put it that way, something that you just kind of assumed that you should be able to exercise. I'm a product of the University of Memphis State University, University of Memphis. I was about 2 years maybe ahead of the actual student movements on campus. So I'm in between that people speaking out and demanding, the right to attend the university, and students in that next generation who were a part of all the free speech movements that were kind of sweeping the country. So I think I've always assumed that it was there. And then as a historian, as a scholar, as a student, as a writer about history, and as a teacher from high school into university, I've always taught the Constitution as a very important part of understanding American history. And as I tell my students, I used to tell my high school students, you can't really understand American history. You can't come to me to kind of help you understand American history if you don't understand the Constitution and the place of the way in which freedoms have been incorporated in American history from the colonial period. So I think for this segment, maybe I'll just talk a little bit about, since I'm a historian, of where all this idea of freedom and the rights and responsibilities of Americans living in a free society, where does this come from? And I think you have to go back to back to the beginning with the English colonists as they are settling in what becomes British North America, as well as in other parts of the British, what would be British Western Hemisphere. They bring with them a tradition of the rights of Englishmen, of the rights of themselves, the rights that people have, that they have as Englishmen and Englishwomen. And a part of this, of course, it dates back to the 1200s, it dates back to the Magna Carta, and very early, almost as soon as the settlements were set up, those settlers began to establish these same principles of the rights and the relationships between the public, the government, the law. They established this in their colonies. In 1619, we usually think of this as the date in which the first people of African descent who are enslaved come into the British colonies. But it's also the year 1619 when you get the establishment of the Virginia House of Burgesses. So that's representative government. That's the idea of government that has limitations, and a respect for the rights of people to form their own governments in the colonies. And the realization that once they get to the colonies, they did not leave these rights in England just because they are separated from their government and their people by an ocean. Then very early, of course, the colonists themselves, as they set up their governments, they began to incorporate some of these basic rights into the constitutions that they established. In the 1600s, you see colonies like Massachusetts and Rhode Island and Connecticut, 1600s and early 1700s, incorporating things like rights to freedom of religion, most importantly. However, it's important to understand that they don't necessarily mean the free exercise of religion for all people. They mean in particular colonies that they have come here from England, escaping what they consider to be religious persecution, to settle in this new land that is new to them, to exercise what they consider freedom of religious expression. So it's freedom of religion that is limited to whatever particular group of people they're dealing with. It could be the Catholics in a certain colony. It could be the Puritans and Pilgrims in certain colonies, settling there to create their own religious institutions. And they also really they focus on this idea of freedom of speech, that as Englishmen who are living in the English colonies, they brought these limitations on the powers of the government and their rights as a people. And part of this has to do with their right to express themselves, whether it's in the press or whether it's in speech and what they say to each other and what they say about their governments. So in the 1700s, you have, of course, the John Peter Zenger case, which deals with this question of slander. And it establishes that you can't really slander a person if you're telling the truth. So, I mean, it's that idea of probably like this crossing over, this interaction between freedom of speech and freedom of press that you see incorporated into that First Amendment right. And then, of course, you have the American Revolution, and again, colonists feeling that England has somehow treaded on their rights as Englishmen or English people, because, of course, there are women here too, but that England is treading on this because even though they've been allowed to establish representative government, and even though they have a seat at the table, a seat in the room, we'll put it that way, in terms of the British and Parliament and their representation, the idea that there are certain rights, like taxation, that they should have a say in, that they should not be taxed by the English government. The taxes should be arrived at based on what the people in the colony believe. So no taxation without representation. Britain would say very simply, but you are representative. Look, you have Ben Franklin standing behind the table or standing with the people who are in Parliament voting on these taxes. So it's not an issue. But the colonists themselves kind of see this as something that is pushing them toward revolution, this perception that their rights as Englishmen are being trampled on. So it's this concept of rights that leads them into the revolution, the belief that their rights are being trampled on, whether they are or not, that leads them into the revolution. And then in the aftermath of the revolution, into creating their own government, first under the Articles of Confederation, but then later in 1787 to 1789, in developing this new federal constitution. And I think one of the most important things with federal constitution in terms of these rights is that you have a clear statement of what are the powers of the different levels of government and how these powers of the federal government and the state governments, how the system actually works, what's the framework. But there's one thing that almost as soon as they had finished the Constitution, that they realized that we left something out, and that was a statement of the rights of the people. So the first, almost as soon as they get this thing ratified in 1789, they've got to basically go back to the drawing table and say, okay, people want to have their rights spelled out. They've known that these rights existed all the way from the 1200s. This has been a core belief among people among Englishmen, wherever they are, is this perception of their rights. So we want a statement, we want a Bill of Rights incorporated into this federal Constitution, and it is as the first 10 amendments within 2 years after the document is ratified. And I think the most important thing for this particular program is, of course, that the First Amendment, the first one that they put in the document, has to do with freedom of speech, freedom of press, freedom of religion. It's not, all these other freedoms like trial by jury and all of this. It's that those basic core principles of freedom of speech. Now, that doesn't necessarily mean that when we say freedom of speech, it doesn't necessarily mean that we have it clearly understood what freedom of speech involves, because like many other ideas that are in the Constitution, it's pretty much left up to the Supreme Court to figure out exactly what do you mean, freedom of speech. You cannot just have a free words coming out of your mouth whenever you want them to come out and call that freedom of speech, because there are some cases in which this absolute expression of freedom of speech might be harmful to the public as a whole, or this absolute expression of freedom of speech may infringe on the rights of other individuals. So your freedom of speech, or your understanding, your idea of what is free speech, might end up infringing or harming my ability to enjoy the rights that the Constitution guarantees to me. So there are limitations, there are prescriptions, there are understandings that freedom of speech is not whatever you choose to say at any particular moment. That you can't, there's still slander, there is libel, there is harmful speech, there is speech that harms society as a whole. And there's also the recognition that what the Constitution says is that Congress or governments cannot infringe on freedom of speech. But in businesses, in private institutions, in educational public schools, for example, that there are areas, you might say gray areas, in which you might assume that you have this free expression, but you don't necessarily have it. That freedom of speech can mean a lot of things. And there's such a thing as what they call symbolic speech, that how you treat the American flag. You don't have the absolute freedom you don't have absolute authority to express your freedom in the way that you treat certain symbols. That the First Amendment, because it says Congress shall, well, just to kind of go back and just see what it says Congress shall make no law respecting or an establishment of religion, so freedom of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So you've got all of that in this one constitutional amendment that seems to kind of say everything that Englishmen had always felt they should have. But it's really focusing on what government has the power to do. And even though it says Congress, it means government on all these different levels. means state, means local, means federal. It means government in terms of different branches of government. That these are things that government cannot do. And of course, because this is in the Constitution, who has the power to determine or who has the power to interpret it falls back on the Supreme Court. But there are all kind of gray areas, as I said before, like slander. You can't slander or libel a person. But then on the other hand, government, Supreme Court, you could say, has kind of looked the other way or been a little less stringent in their interpretation or the limitations of what are the limitations of freedom of speech or what is allowed to a government at different points in history. Because you've had, over the course of this 200 plus years of history, you've had different times when the government has passed laws or what we call sedition acts, limiting the speech or limiting the rights of individuals to express themselves based on, you could say, certain larger issues or things that the government has considered to be larger issues, that you cannot commit these acts of what it interprets as sedition. And then you look up and maybe about, I don't know, a few years later, Supreme Court will say, well, no, that's, we're going to have to let that expire, and we're not going to, it's not going to be, Congress will say, we'll let it expire, we won't reinforce it. So you've had in the 1800s Alien and Sedition Acts that limit the free expression of individuals, freedom of speech. So, yeah, and I think by the time, like I said, when we got to the 1960s and 1970s, I can remember as a student, I remember as a young person, and as a teacher, my first few years teaching in a high school, that was a period in the 60s and 70s and in the early 80s when my high school students look back on 1968 as the year and wishing that they were able to express themselves in all the ways that, as they put it, you people, you young folks did when you were in 1968, so why are you limiting what we say right now? But that was a period in which people just kind of felt that you had this absolute right to express yourself, but understanding that there were some restrictions on this expression. And increasingly that you would see maybe more government restriction on this. So, maybe government would say that you cannot, there are some expressions and there's some artistic expressions. You might see art as being an area where free speech would be just, everybody, it's art. So you just kind of go with it. But there are limitations that the court has recognized in terms of this expression, this artistic expression. So it's not totally free. As Americans, we understand that the Constitution provides these protections of rights. We understand that freedom of speech is there, and we just it's kind of like our fallback on, I said this, so I said it because I have the freedom of speech to say it. And maybe sometimes we haven't really understood that we have these freedoms, but then there are levels and ways in which government can interpret or how we express that freedom. But I think that the through line that I've always seen, when you ask the first question about when did I first understand it, I think I've just always perceived that it was there. So when I see expressions of things like Black Lives Matter, it just it overwhelms me that people would not really understand what that meant. That, of course, that matters. And the idea of Black Lives Matter in terms of, well, what does it mean that they matter? It doesn't just mean that you have no right to kill a person in the middle of the street, as with George Floyd, that you have no right, that you have violated his right to life and liberty and all of this, which, Constitution doesn't really spell that out completely. That's Declaration of Independence, that's great, but where is the Constitution? And I think that for me, the through line is that that people need to understand that Black Lives Matter also says that everybody, all Americans, have these same rights, and that my life matters not just simply in terms of my physical life, but my ability to participate in this government, in this country, and my ability to be recognized, my citizenship to be recognized. That's something that's been a through line all the way from the 1700s, late 1700s, is this idea that you have a right to participate. And we've been refining this right to participate and to be seen as mattering since the 1700s. That at the very same time as Americans were starting this Virginia House of Burgesses and representative government, in that same year you had the first Africans brought in as indentured servants, but a status that would kind of evolve or devolve into permanent bound servitude, which was something that this Magna Carta and English common law had made very clear could not happen to Englishmen, and to people, and that English governments could not do this to their people. That you could accept the fact that there were these rights and freedoms on one side, but on the other side, you're building up a whole economic and political and social institution that will deny these rights and privileges to people of African descent, to Native Americans, and would not really recognize these as rights that women were entitled to. So what you see happening is that at the same time that you have demands for the recognition of rights that have been commonly accepted as rights, you have the evolution of systems that are denying rights and that have to be constantly challenged. And Americans have to be constantly reminded, to some extent, that, hey, you've got freedom of speech, or I have freedom of speech. And then, but there's restrictions on this, that there are interpretations, ways of interpreting it. So that's been the through line all the way that I can see, that it's been a struggle. I said freedom is a constant struggle. And it's a struggle for the rights that people perceive. And I can sit here and talk about freedom of speech, but I also recognize that in a public institution, I don't have necessarily the same rights of freedom of speech as if I were teaching in a private institution. Or if I'm working in a private institution, because it is a private institution, governed by certain laws or certain rules within that establishment, I might not have the same rights as if I was sitting in the public institution. So freedom is there, freedom of speech is there, but it's been something that's been restricted and opened, and door opens, door closes, doors opens a little bit more, but then door closes a little bit more. So it's something that you have to constantly fight for, like every other freedom. So.
Hi, my name is Joel Nichols, and I am a professor of advertising, branding, and creative strategy. I want to speak to you for a minute about the First Amendment and how it relates to advertising. The First Amendment guarantees freedoms concerning religion, expression, assembly, and the right to petition. It essentially says that Congress is prohibited from restricting the press or the rights of individuals to speak freely. With all of that said, in my view, the essence of the First Amendment is about freedom of expression, which relates very closely to creative areas such as advertising, branding, copywriting, or design. However, while advertising is a form of expression, it is considered to be commercial speech. As such, we in the advertising field have a responsibility to be lawful in our messaging and not be misleading. This walks a fine line between what we do creatively in advertising and the free speech that is protected by the First Amendment. After all, our job is to be creative, to be engaging, to break through the clutter and grab your attention. Advertisements over the years have pushed the boundaries of what is real and what is not, just to sell a product. There have been many instances where advertising pushes the boundary of what's acceptable, especially when it pertains to how items are marketed to children or claims that are made in ads for medical products. As someone who teaches in the creative area, I exercise the First Amendment by pushing students to be creative with their strategies, designs, and messaging. But I always make sure I instill in students the importance of not being deceptive or pushing a boundary beyond that which is appropriate. While we are afforded the freedom of speech under the First Amendment, in commercial speech, we must be careful not to produce ads that are untruthful or outright misleading to customers. We have a responsibility as advertisers to be creative and truthful at the same time. So when students develop ad campaigns, messages, or designs, I push them to be creative, to try new things that have never been done before. But I also teach them the importance of not abusing the First Amendment by producing something that is simply not true. And as an educator in this field, that is how I exercise my First Amendment right in advertising. Thank you.
We're taking a quick break from our news engagement showcase to let you know that we're having a Freedom to Create contest, encouraging you students to showcase your knowledge of the First Amendment and your talents through songs, videos, photography, journalism, graphics, art, social media campaigns, poems, stories, speeches, and essays. The contest starts on October the 8th and wraps up on November the 8th. More details are coming to your university email soon.
Hello, everyone. I'm Mark Paraskia, Director of the Institute for Public Service Reporting here at the University of Memphis. I'm going to talk a bit today about freedom of the press. The First Amendment to the Constitution of the United States says Congress shall make no law abridging freedom of the press. So what does that mean, abridging? It's another way of saying curtailing or limiting. So in other words, the government can't curtail, limit, or diminish our constitutionally guaranteed press powers. And what are those powers? What is freedom of the press? Merriam-Webster Dictionary defines freedom of the press as the right of newspapers, magazines, etc., to report news without being controlled by the government. History.com defines it as the right to report news or circulate opinion without censorship from the government. Supreme Court Justice Hugo Black put it this way in the landmark Times v. Sullivan case: the freedom of the press, protected by the First Amendment, is critical to a democracy in which the government is accountable to the people. A free media functions as a watchdog that can investigate and report on government wrongdoing. So it's this component of freedom of the press, the power to investigate government wrongdoing, that I'd like to discuss today. There are a few ways that journalists investigate wrongdoing. One involves basic news gathering. That includes the ability of reporters to freely interact and obtain information confidentially from sources or people who work with the government or are in a position of power to hold certain privileged information. Most states have adopted so-called shield laws that allow reporters to protect their sources, to shield these confidential relationships, to promote the free flow of information that is the lifeblood of our democracy. Accordingly, reporters cannot be compelled to divulge the names of their sources. Another way journalists investigate wrongdoing is through the pursuit of public records. The federal government and each of the 50 states have freedom of information or public records laws that guarantee journalists and the public at large access to government records. These records range from police reports to financial documents, audits, and a spectrum of other paperwork affecting vital issues such as voting rights, the environment, taxes, defense spending, road construction, housing, and the like. Despite these laws, government officials often don't want to release these records. Journalists must fight to obtain them in these cases. Sometimes that even involves filing suit in court to win release. Over my career, I've been involved in a variety of public records cases in which I and my news organizations had to sue the government in pursuit of public records. That includes a couple of landmark cases. Way back in 2000, I sued for access to public records of a government contractor that was receiving millions of dollars from the state of Tennessee to administer a taxpayer-funded child care program in Shelby County. I learned in my investigation that though the program was intended to benefit poor families, huge sums of money were being siphoned off for executives to buy fancy cars, expensive homes, and take lavish vacations, including a Caribbean cruise. Critically, these duties performed by this contractor, including certifying qualifying families for admission into the program and paying daycare operators, previously had been performed by the state. The case went all the way to the Tennessee Supreme Court, which sided with me and my then employer, the Commercial Appeal. The court found that private entities can be subject to Tennessee's Public Records Act if they act as the functional equivalent of a government agency. In other words, the government can't hide records simply by privatizing government functions. The precedent set by the court's Memphis Publishing Company versus Cherokee Children and Family Services ruling has had wide impact. It's been used by news organizations to gain access to investigate a variety of issues, including exploring conditions in privatized prisons. In another case, I sued the Federal Bureau of Investigation seeking access to records related to its surveillance of the civil rights movement in the 1960s and 70s. In this case, settled in 2013, the Commercial Appeal and I gained unprecedented access to information establishing that famed civil rights photographer Ernest Withers had served as a paid FBI informant over the course of 18 years. More recently, I sued the city of Memphis earlier this year for access to police body camera footage. Access in this field remains a critical ongoing battle. Officials have sunk millions of dollars in taxpayer money into body cam programs all over the country while pledging to make policing more transparent. They did this to shore up public trust that's lagging because of incidents like the police murder of George Floyd last year in Minneapolis. But the problem is body cam programs are anything but transparent. Police departments like MPD often charge thousands of dollars for body cam footage. That's unaffordable to most news organizations, let alone your average citizen. Police often take months and even years to release footage. In my case, we settled with MPD when officials agreed to release footage from 3 incidents in which an officer was accused by internal investigators of misusing his taser on citizens. The footage cost me nothing, thanks to the Reporters Committee for Freedom of the Press, which provided attorneys to represent me free of charge in court. The cost of bringing suit is a major issue facing journalists today. Newspapers like my old employer, the Commercial Appeal, once had huge budgets. That enabled us to routinely sue non-compliant public officials to help keep them honest. But now, with the decline of legacy media, filing suit is less of an option. That's hindered by access to public records, and it hurts the public at large. Together, we must create more opportunities for access. We must pool resources with those offered by the Reporters Committee. This will help us shore up our press freedoms, preserve the right of a free press to independently investigate government, and help preserve our cherished democratic ideals. Thank you.
Hi, my name is David Waters. I'm Associate Director of the Institute for Public Service Reporting at the University of Memphis. I'm here to talk to you today about freedom of the press in the digital age. I've spent my entire career working as a news journalist, This is a picture of my license to practice journalism. It's called the First Amendment. As a journalist in America, I work on behalf of the First Amendment. As a reporter, I cover free assemblies and freely made petitions to the government. As a columnist for many years, I exercised freedom of speech. As a religion columnist for many years, I exercised freedom of religion. And obviously, as a journalist, I exercised freedom of the press. It's important to remember that those 5 fundamental freedoms proclaimed in the very First Amendment to the Constitution are not granted to us by the government or by a document. Those fundamental freedoms are recognized by government, and because of that document, protected and defended by government. They are natural rights we all share as free men and women. And all are products of the single most important freedom we all share, the freedom of conscience. We are free to think whatever we want. And we are free to say what we think without government interference in public, in person, in print, and online. That might seem obvious or normal to you, but for most of history, that hasn't been true for most people. In fact, it hasn't always been true in America. Consider this famous quote: "Let us dare to read, think, speak, and write." John Adams, the American revolutionary, wrote that in 1765 in the Boston Gazette newspaper. About 30 years later, John Adams, the American president, oversaw passage of a law making it illegal to, quote, "write, print, utter, or publish any false, scandalous, and malicious writing against the government." At least one congressman and more than 20 newspaper editors were arrested and imprisoned for criticizing the Adams administration in the press. That suppression didn't last long. Adams lost his bid for re-election, and the Alien and Sedition Acts were repealed. The free press was free again, but the right to a free press, like the other rights in the First Amendment, is not absolute. Freedom of press has encountered any number of challenges, both legal and illegal, over the past 2 centuries. I want to talk to you about an entirely new challenge to freedom of the press. That's the internet. 20 years ago, more than half of Americans said they got their daily news from local print newspapers. About 10% got their news online. Today, those numbers have more than flipped. Only about 10% of Americans get their news from print. Nearly 90% of Americans get their news online with a smartphone, tablet, or a computer. And more than half of them get their news from Google, Facebook, or other search engines and social media sites. New media has had a profound impact, both good and bad, on old media, and it's also having a profound impact, both good and bad, on freedom of the press. The First Amendment freedoms are intended primarily to protect us from government interference in those freedoms. That's why we call it the First Amendment, and that's why it begins with the words, "Congress shall make no law." That applies to state and local governments as well. This does not necessarily apply to non-government private actors such as corporations. We can read, think, say, and write what we think in our workplaces, but the companies that own or manage those workplaces can make policies that legally restrict what we say and do. Likewise, what we can read, think, say, and write and post, we can do that what we want on websites and social media platforms. But the companies that own those sites can remove us and our expressions if we violate company policies. For example, after the brazen attack on Congress in the US Capitol last January, Facebook, Twitter, and other social media companies banned President Trump and several members of Congress from their platforms. Think about that. The President of the United States of America, the leader of the free world, the most powerful person on the planet, was banned from social media. There is no First Amendment right to speak on social media, but courts have ruled that social media companies do have a right to ban people and content from their platforms. How does that impact freedom of the press? Let's take a look. As I said earlier, most Americans are now getting their news and information online. More than half are getting their news via social media platforms owned by just a few big companies. Facebook, which also owns Instagram, Twitter, Reddit, and YouTube, which is owned by Google, the leading search engine, which also happens to own Chrome, the leading web browser. Google, Yahoo, and AOL are 3 of the top 7 news sites in the world. More than half the traffic to major news sites arrives via Google or Facebook. In other words, a handful of internet-based companies have great power over the distribution of most news and information online. For all intents and purposes, they own the printing presses. How do they wield that power? How does that impact freedom of the press? Here are 3 things to consider. The internet drives decisions about news coverage. The business model for online companies depends on getting and keeping users engaged. Content that prompts some sort of reaction, a click, a like, a comment, a share, tends to generate more clicks and shares and add revenue. That high response content is what social media algorithms tend to promote. News stories about murders or insults or conspiracy theories or football games or celebrities or kittens tend to draw more clicks. Those stories trend, rising to the top of site and search engines and social media platforms and feed on themselves. News organizations which also need clicks to generate revenue pay more attention to stories and topics that click. That digital sorting leads to another challenge. The internet traffics in confirmation bias. The more search and social companies know about us, the better they get at serving us content and ads we like or agree with or click on. And the better they get at filtering out content and ads we generally don't like or agree with or click on. In other words, new media algorithms steer us toward news and information that reflects our own personal, political, and ideological preferences and away from those that don't. As a result, we are much less likely to be exposed to other information, other ideas, other viewpoints online. If you click or like or share posts that promote COVID vaccines and masking, you'll see more posts like that. If you click or like or share posts that say COVID is a hoax or vaccines are dangerous, you'll see more posts like that. Social media platforms tend to ensure we only get a single side of every story, the side we agree with or trust. That can harden our own confirmation bias through news and information that affirms our beliefs and biases and ignores information that challenges or refutes them. That leads to an increasing political and social polarization. And that brings us to a third challenge. The internet traffics in disinformation. Social media algorithms not only reward popular posts, they also reward disinformation. Lies tend to go more viral more quickly than true statements. So do conspiracy theories, distortions, and exaggerations. Disinformation is intentional, false, or inaccurate information aimed at achieving a social or political goal. Here's one example. The summer before last year's election, a pro-Trump group called Freedom Works promoted 150 Facebook ads that directed viewers to a page with a picture of LeBron James, the NBA superstar. The image was accompanied, wasn't this image, by the way, the image was accompanied by a quote by James. He denounced poll closures as racist, but the quote and image were twisted to make it seem like James was discouraging voting by mail. In truth, James widely and loudly supports voting by mail. The ad was false, but the disinformation was seen by hundreds of thousands of times before Facebook removed the page. The disinformation was never corrected, and no one was prosecuted for fraud. The internet in general and social media platforms in particular are rife with such disinformation. Suzanne Nowell, CEO of PEN, the world's leading advocacy group for open expression, put it like this: Rampant disinformation imperils the values and civic benefits that the First Amendment is intended to uphold. So even though disinformation is constitutionally protected, the fate of free speech and open discourse, and maybe even of democracy itself, hinges on our ability to get it under control. That brings us to Section 230 of the 1996 Communications Decency Act. Generally speaking, Section 230 made the internet possible. It makes internet platforms immune from libel and other civil complaints for the content they carry. In effect, internet companies are not legally liable for the content that is posted by others on their sites. If I write something defamatory about you on Facebook, I can be held liable, but Facebook cannot. But if I write something defamatory about you in the New York Times, or say something defamatory about you on ABC News, those companies can also be held liable. Some argue that Section 230 gives new media a big financial advantage over old media. They claim that the ethical norms and legal burdens carried by old media put them at a market disadvantage for ad revenue and customers. Others claim that 230 merely enhances freedom of speech in the press on the internet. Should Section 230 be revoked? Should internet companies be held responsible for the content they distribute? Does the constitutional right to freedom of speech and press protect disinformation? Should it? Are social media platforms that remove disinformation censoring free speech or free press? The right to free speech and press is intended to protect dissent, especially dissent against the government. Is disinformation about the government a form of dissent that should be protected? Or is it a form of libel, slander, or deception that should be regulated by government? Lawmakers and lawyers and judges and all of us will be addressing and debating these questions for generations to come. But we all agree that the internet, social media, and digital forms of communication have created new challenges for the Constitution's guarantee of free speech and press. Let us dare to read, think, speak, and write what we want, but be careful before you publish or post it. Thanks for taking time to listen to this.
As a current graduate student studying journalism, the right to peacefully assemble is extremely important to me. Whether it's attending a peaceful protest in my community to document what's going on, or getting together with a group of graduate students to study and bounce ideas off of each other, these things contribute to my growth, my education, and me as a person.
As a journalist, naturally, I hold the First Amendment in very high regard. As a matter of fact, I think it's one of the most important tenets that the founders created when they crafted the Constitution. Particularly, in my view, freedom of the press and freedom of speech. But there's also another freedom of the five that is just as important, and that's the freedom of assembly. You know, Dr. Martin Luther King said in 1968 in a speech right here in Memphis that the Constitution guarantees us the right to protest for right. And I think that's very true. So what I want to talk about is, I want to talk about three incidents in history, one of them very recent history, in which the First Amendment freedom of assembly was mired in some controversy. The first one happened in 1968 and involves Dr. King. Back in 1968, in February, 2 city sanitation workers were killed when they were collecting garbage in East Memphis. They were crushed in the back of a garbage truck. The result of their deaths was that the city refused to pay any death benefits or even cover their funeral expenses, and they were already making very meager salaries. The sanitation workers took this as a major affront and went out on strike. And they stayed out on strike for the better part of 2 months. And it was a terrible time in the city of Memphis. Dr. King was asked to come to Memphis to support the sanitation workers, and he agreed to do so. So in March, on March 22nd, as a matter of fact, of 1968, he planned to hold a march, and he came to Memphis and he talked about the importance of this as a civil rights issue. The march was postponed because of a snowstorm, but it was reset for March the 28th. The march was held down Beale Street, but when it got near Main Street, some windows were broken. And police, who were already there, sort of waiting to see if there would be any disturbances, they pounced on a lot of the marchers using tear gas and batons, and Dr. King was whisked away. During the confrontations, a young African-American man named Larry Payne, 16 years old, was shot to death by a police officer who said that Larry came after him with a butcher knife and accused him of breaking some of the windows. Of course, by that time, Larry was far away from the march site, and so his death didn't even happen right there at the scene. And so it was a major, major controversy. Dr. King was heavily criticized for not being able to lead a peaceful march or get a peaceful assembly anymore. But he wanted to prove his critics, especially in the media, wrong. And so he vowed to come back to Memphis to hold another march, another peaceful march. City leaders, including the mayor, went to court to stop it because they said that there was no way to have a peaceful assembly. And initially, the city received a temporary restraining order to stop the march. But Dr. King came back on April 3rd, 1968, recruited the services of Memphis lawyers to go to court and fight to have the temporary restraining order lifted so that they could have a peaceful assembly under the First Amendment of the Constitution. The day after Dr. King's mountaintop speech, which was on April 3rd, his lawyers went to court, got the injunction lifted, and the march was planned for the following day, which would have been April 5th, 1968. But as we all know, on the evening of April 4th, Dr. King was assassinated at the Lorraine Motel. And of course, we know what happened after that. Following his funeral, there was a march, a peaceful march, with thousands of people here in Memphis. It was led by his widow, Coretta Scott King. Harry Belafonte, Ralph Abernathy, and others came to Memphis and held that march, upholding the First Amendment right to assembly. The second incident I want to talk about happened just last year in Memphis and across the nation. And they were marches around Black Lives Matter. We all know what happened with the death of George Floyd in Minneapolis in May of 2020. But there were other incidents of police shooting people of color, Breonna Taylor and others. But the death of George Floyd with the police officer's neck on his knee just sort of sparked a major reckoning with race. And people took to the streets as a result of it. Now, yes, in some instances, in some places, there was violence. Things did get out of hand, including in Nashville. Here in Memphis, things were a lot more peaceful. There was controversy around that because critics claimed that those marches and those protests should not have been held because they were not peaceful. But for the most part, they were. And they were all over the country, from the East Coast to the West Coast. And it did lead to a reckoning of race. A lot of things changed in business, in entertainment, in sports. And this became a worldwide movement that there needed to be a reckoning with race. And I believe that a lot of it occurred as a result of people taking to the streets and exercising their constitutional right to assembly. Yes, interstates were shut down and streets were shut down, but for the most part, these protests were peaceful, which is what the First Amendment says. You have a right to peaceably assemble, and that's what happened then. The third one I want to talk about is a lot more controversial, and it happened earlier this year. It was the insurrection at the U.S. Capitol on January 6, 2021. It started as a protest. People gathered in Washington. They were supporters of then President Donald Trump. They were not happy that he had been declared the loser of the 2020 presidential election. And they came to Washington to voice their opinion and their views and to assemble as a result of that, which was perfectly fine under the Constitution. They met, they heard speeches from the then president, also other members of Congress, other supporters of the president. And then they decided, at the urging of the president, to march to the Capitol. And even that was fine. Marching to the Capitol, letting their voices be heard, is what the Constitution stands for. But this group did get out of hand, and they violated the tenets of the First Amendment because they resorted to violence. And we've all seen the pictures of climbing into the windows, breaking them, parading into the Capitol, storming the Senate chambers, bursting into the offices of lawmakers, including House Speaker Nancy Pelosi, parading through there with flags, threatening to hang the Vice President, Mike Pence, and causing him to flee for his life, and carrying the Confederate flag through the halls of Congress, attacking police officers. I mean, it was a shameful day in America. But it started out as an assembly that is protected by the Constitution. So, again, when we look at the First Amendment, I don't think that there are any more precious rights than those 5 that are listed there. Freedom of religion, freedom of speech, freedom of the press, the right to peaceably assemble, and to petition the government for redress of grievances. Those are wonderful, wonderful tenets in our First Amendment. And we should uphold those, each and every one of them. But there are some times when the right to assembly does get out of hand. That certainly happened on January 6th of this year. But we should always remember, as Dr. King said way back in 1968, that the Constitution gives us a right to protest for a right. And that's my view on the First Amendment, freedom of assembly.
The right to petition the government is a freedom that plays a key role within our democracy. It gives citizens the right to stand up and speak out against all injustices, whether they are occurring from the government or elsewhere. The right to petition gives citizens the power to change those injustices.
Good morning, or afternoon, or evening, or whenever you're listening to this. My name is Paul Mago, and I'm a senior lecturer in political science at the University of Memphis. My office and classes are at the University of Memphis, Lambeth, in Jackson. I'd like to talk a little bit today about one of the 5 freedoms that we find in the First Amendment to the Constitution. First, I think it's important to mention that while we call these freedoms, they're really potential actions that are in fact protected by the Constitution as the highest law of the land. The First Amendment to our Constitution certainly includes reference to several fundamental liberties and protections of those liberties for those living in the United States. What seems to be implied and even institutionalized primarily in this amendment is the basic protection that I personally think is our most important freedom, although not specifically recognized by name, the protection of our right to dissent, and especially our right to dissent publicly against government actions with which we might disagree. Of course, while the protection of free speech, a free press, and freedom to peaceably assemble also might imply the right to dissent, the final protected action in this amendment, written as, quote, Congress shall make no law abridging the freedom to petition the government for a redress of grievances, seems most clearly related to our right to dissent, and that this right must be specifically protected. This is especially interesting to me since a 2017 poll I saw recently said that only 3% of those randomly surveyed were able to name this freedom to petition the government for redress of grievances as one of the freedoms protected in the First Amendment. You can read into that what you will. Historically, the right to petition has played an important role in the United States. During the colonial period in America, when formal petitions by colonists for redress of grievances perceived to have been committed by the British government and King George III were ignored by that government, the result was a formal declaration of independence and the Revolutionary War. As with many aspects of our current political ideology in the United States, the formal and protected right to petition the government for redress of grievances is specifically spelled out in our Constitution after being ignored in British government structures. We didn't like what they did, so we resolved to do it differently. As this freedom has evolved currently, some legal experts have considered that the basic elements of this protected right have almost become obsolete, since it's closely related to the Free Speech Clause. However, we can also understand that this right to petition for a redress of grievances specifically can be regarded as separate from simple free speech. In order to recognize the difference, the concept of petition ought to be considered. Yes, we have the right to speak out against perceived wrongs by government, but the idea of a protected right to petition may be different from simple protected free speech. In this context, I'd like to consider some aspects of this protected right in a little more detail. In preparation for my comments on this part of the First Amendment, I discussed the clause with a friend of mine who's a former constitutional lawyer and is currently a federal judge. In our conversation, we came to the conclusion that this is one of the simplest and most straightforward of our First Amendment protected freedoms. One of the most important implications of this statement is that the concept of petition means that we, the people, have the freedom, in fact, to sue the government formally in a court of law if we think the government has wronged us. And that freedom to bring a legal suit against government is protected in our Constitution. Again, Congress shall make no law abridging the freedom to petition the government for a redress of grievances. Yeah, pretty clear and straightforward, considering that the concept of petition certainly includes formal legal proceedings. But our conversation revealed some other aspects of this freedom. We considered that while it's relatively rare to have this First Amendment protection invoked legally, it certainly has elements that bear some further scrutiny, as do most of those freedoms protected in our First Amendment. As a lawyer and now a judge, my friend told me that in the eyes of the law, all the basic elements of this clause are open to some interpretation. Who has the freedom to petition the government? What defines a petition? Are there legal, formal requirements? What governments, and we have many different levels in the United States, can be petitioned? What exactly defines a grievance? And what are the limits to the redress of those grievances? As with much constitutional law, each separate case that includes the petition clause must consider these elements and decide them in the context of the situation. That's why we have constitutional lawyers, to interpret the legal nuances of our Constitution. However, one part is very clear. This right to dissent must be through legal means. And legality is one of the most important issues to be aware of with this freedom of ours. We have this right, and it's protected by our rule of law, but as in much of law in the United States, which is of course one of the reasons we have so many lawyers and lawsuits, the details are what seem to matter. In regard to some of these details, let's look briefly at the terms included in the clause. Who can petition? Citizens, definitely. Non-citizens' right to formal lawsuits against government is less clear. What is a petition? Well, basically, and most often, this formally refers to a legal lawsuit, and the concept of redress basically refers to a remedy or compensation for grievances to be determined by the court. Grievances can be complaints, protests, perceptions that someone has been wronged by government. We found and reviewed a U.S. Supreme Court case from 2011 that specifically invoked the petition clause that helped to inform me about some of the specific issues that may be involved with invoking this protected right as well. The lawsuit began as a suit against a local government for the wrongful dismissal of a public employee. The case was subject to arbitration, which resulted in the employee's reinstatement, but the government imposed certain specific requirements for that employee after reinstatement, including a denial of overtime pay. This additional government action resulted in an additional lawsuit that claimed that those imposed requirements were in retaliation for reinstatement and thus violated the right to petition clause in the Constitution's First Amendment. The case went to the U.S. Supreme Court, which then ruled that the suit, the petition for redress of grievances, was a constitutionally protected activity, and the requirements imposed on the employee after reinstatement were unconstitutional. A public employee who has petitioned the government through a formal mechanism, such as the filing of a lawsuit, is protected under the petition clause from retaliation for that action, even if the petition is a matter of solely private concern. And this is important. The clause does not apply only to matters of public concern. The employee who brought the suit won the case, and in doing so, added some clarification to that clause. The court's ruling determined that while citizens have the right to petition the government for redress of grievances involved in private concerns, that petition must also take into consideration the interest of the government in the effective and efficient management of governmental affairs so as not to be overly disruptive. So, our right to sue the government for redress of perceived grievances is limited. It must not cause undue disruption of government activity. This case and the perspective of legal experts certainly provide interesting elements to this constitutional amendment. Other formal aspects of this protected right to petition might be seen as well in current events, such as the petition to hold a recall vote in regard to grievances held against actions of California Governor Gavin Newsom. While not all states have the specific ability to hold such recalls, and the federal government certainly does not, this action can be seen as an exercise of the right to petition for redress of grievances against the government. There are perhaps other more informal aspects involved in this protected right that citizens might consider. Clearly, we can dissent, at least currently and for the most part, against actions that we think government has done and that we feel may be wrong and harmful. There are lots of ways that people can petition for redress of those grievances that may not include formal legal actions. Again, though, they must be done legally. Other important forms of petition for redress of grievances against government can, for example, take the form of working to construct ballot initiatives, if those are legal in a state. Even the act of lobbying, formally through lobbying organizations or informally through letter writing, email campaigns, social media comments, could be considered a form of petition for redress of grievances against government, as could peaceful protests and even picketing, both of which have historically been very effective during the Civil Rights era as well as during the years of the Vietnam War. As the previously mentioned Supreme Court case pointed out, though, government can also impose reasonable restrictions on the right to petition. They must indeed be legal and not be overly disruptive to the necessary work of government. This brings to mind a final point regarding the right to petition for redress of grievances against government that I've been thinking about ever since I was asked to make this recording. The events at the U.S. Capitol building on January 6, 2021. The right to petition is clearly a protection of our right to dissent and may take many forms. But for our right to dissent to be protected, it must clearly be legal and therefore non-violent. Well, the protesters at the Capitol that day certainly had perceived grievances, especially since so many legal actions found no satisfaction for them, and they had the right to dissent. Some ultimately chose to petition for redress of grievances against the government using violence. And this form was not a constitutionally protected form of petition. That's it. Thanks for listening.